The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Said. Today we're talking about whether an agreement is enforceable. Strictly speaking, what I want to be talking about is agreements for land. So not general contracts, just things in New Zealand where people are trying to transact land. So, when is an agreement enforceable? Lucky for us, the legal position is relatively clear because Section 24 of the Property Law Act 2007 provides that any contract for land must be in writing and signed by the parties. So, that's our certain part. As soon as we start to unpack those ideas, that's where we can get into a bit of trouble. So what does it mean it being in writing? Well, traditionally that would mean physically on paper, but in the modern era, in writing can be through email, it can be through text message, it could be written on stone, it could be written on paper. As long as it is physically written down, whether physical or digital, that can constitute a written contract. So then we turn our minds to what it means to be signed. Again, traditionally, you think of your signature as the only way to officially sign a document. Those days have really come and gone in terms of that signature being the only thing that allows you to show that you have signed the document. Again, in the modern times, we've got digital equivalents. So we've got electronic signing verified through something like DocuSign. We've also got blockchain technology and smart contracts where your signature is verified through that blockchain technology. Not very common in New Zealand, but it is becoming more common overseas, and it's going to creep into the New Zealand jurisdiction. In addition to signing, there's also what I kind of consider signing by implication. And this is where we start to get dangerous, that you may accidentally have agreed to something and have signed it. And the best example of that is text messages and emails, where it's really hard to actually say whether you have signed or not signed. But if you send the email to the other party in writing and they verify in writing that they agree to what you're saying, then as a general principle, we see those being upheld as binding contracts. Context is going to be important, the nature of what you've said, how certain what you've said is. These are all factors that are going to come into whether that contract is in fact enforceable. But as soon as you put it in writing, then you're opening yourself up to it being a binding contract. Depending on who you are in that transaction will dictate whether you would definitely love it to be binding or whether you'd prefer for it to be seen as not binding. And that's ultimately going to come down to whether you're getting a benefit or a detriment from that term as it's drafted. In previous videos, I've talked about the importance of getting legal advice before you sign documents, before you communicate to the other party acceptance of any terms. That means that before you send that email directly to the other party, forwarding on what you've received from them to your trusted legal advisor so that it can be reviewed, you can be advised as to definitely what the implications of those terms are, and then from there you can make an informed decision as to whether you accept those terms directly with the other party, whether you get your lawyer to respond to their lawyer or directly to the other party if they're not legally represented, or whether you don't want to accept the terms and you want to start investigating or looking at your legal position to determine whether you have other options available to you. So ultimately in those scenarios, knowledge is power, and if you take pause, you've got the opportunity to ensure that you understand your legal position before being bound by terms that you don't necessarily understand. What I'm seeing more and more in practice is text messages, instant messages, so things like WhatsApp, not so much Snapchat, but I suspect it could be the same in that piece of technology. Anything where you are instant messaging has the opportunity for it to be deemed to be a contract in writing that you have signed by agreement. Those informal forms of communication are often viewed by Joe Blogg as not legally binding. By the time it gets to me, we've already got terms partially agreed and either I'm trying to enforce those terms or I'm trying to unwind those terms. I would say it's probably more likely than not that the terms need tweaking in some way. So it's often the case that although the general principle of what needs to be agreed between the parties is correct, there'll be either minor things that need to be adjusted, or there could be significant things where you just have not turned your mind to a particular risk or a particular problem associated with that type of transaction. This is where your trusted legal advisor is going to be able to assist in making sure that that contract that you're entering into is doing what you want it to do. When it comes to land, we're generally not talking about small contracts. We're generally talking about things that are going to have a big impact on you, both in the short term and the long term. You generally want it to be right. You don't want to be messing around with contracts that are putting you at risk. Your appetite for risk and general understanding, knowledge, expertise in the nature of the transaction you're attempting to enter into is ultimately going to lead to how early you get your trusted legal advisor involved. As always, my recommendation is to get us involved early. If we can review everything at that point, it's generally low cost compared to there being a problem that we have to fix later. And we can be involved in order to do that review, and then you can choose to crack on either with us continually involved for the rest of the transaction, or you might tell us to hold fire. You're going to crack on for a period and then revert to us once you decide that you need to. The key takeaway from this message is that if you're dealing with land, suddenly those forms of communication that perhaps are back and forward, deciding terms with the other party, are suddenly going to potentially lock you into terms that you didn't know you were locked into. Now, so far in this video, I've focused mainly on the risks of entering in and suddenly being bound by something that you don't want to be bound by. Similarly, if you are dealing with someone informally, direct through text message or some other form, and you want that contract to be binding, but you don't have it formalized either through legal advisors or ink to page signature, there is a risk of that agreement being deemed to be not enforceable. The main things are going to be whether it's signed and also whether there's certainty of the terms. And this one is one of the ones where you can get caught out pretty badly if you are wanting something to be binding, but then it turns out that the terms are just so uncertain that it can't be binding on the parties. And that really comes down to the facts of the situation. So it might just be that you literally didn't put enough detail in, and the options available for how to interpret those words are too broad, which means that there's not enough certainty in the wording to allow for a contract to have been formed. As I say, it's going to come down to context, it's going to come down to your specific facts, your specific situation. So anytime that you're wanting a contract to definitely be locked in, it's best to get an advisor to assist you with that process to make sure that you've got a binding contract, and that way you can move forward with confidence. Because one of the worst things you can do in that scenario is think you have a binding contract, in reality not have a binding contract, or at least it be arguable that it's not binding, and then you go and make other decisions based on that contract. i.e., you think that you've sold your house, you enter into a contract to purchase another house, it turns out you haven't sold your house, bing bang boom, you're suddenly in a position where you're locked into a purchase and don't have a sale. Not a great position to be in. You would be shocked at how many times this comes up where the situation is present and could eventuate into full-blown bad situation. 9 times out of 10, everything resolves. But you definitely don't want to be that 1 time out of 10. So making sure that you understand whether you're locked in, whether you've got a binding contract, is going to give you confidence to go out and do whatever you're doing based on that understanding. So today, Simon says, if you want a binding contract, make sure it's in writing. If you want to know that you've got a binding contract in writing, talk to your trusted legal advisor. And remember, at LOA Law, we are good lawyers for good people.